Good morning, everyone, ladies and gentlemen, dear participants, students, and friends of the Lübeck Summer Academy on Medical Technology, dear invited speakers who have prepared to contribute to this day. Many thanks for joining today this meeting, which is organized for the second time now as online meeting with all its advantages and also challenges. As it is already the tradition for the Summer Academy, this day is organized within two subsequent sessions, both relating to, I can say, freshest topics in the field of medical technology. Of course, on the one hand, we are all aware of the application date of the medical device regulation, which is since May 26th of this year, more or less fully applicable for the stakeholders in this sector. The morning session will discuss this topic from various perspectives, including industries and notified bodies perspectives. But an additional regulatory framework most recently came out. It is the European Commission's proposal for a regulation on artificial intelligence, also called already AI proposal. This future regulation will have a really big impact on the conformity assessment of medical devices, including IVD medical devices. And we are therefore really happy and grateful that our keynote speakers, Mr. Salvatore Scalzo and Professor Wolfgang Walster, will address this topic both from the regulatory perspective during the morning session and from the technical standards perspective during the afternoon session. In addition to a warm welcome to our keynote speakers, I hereby express my special thanks to all our speakers presenting during this day, who are all top experts in the field. Thank you so much for supporting the Summer Academy today. The morning and afternoon session will be composed of several presentations, followed by a panel discussion, where also many of our speakers will be happy to discuss with us online. But we shouldn't lose too much time. We should directly move forward, and I would like to introduce you Mr. Salvatore Scalzo. And we are very happy to give you a very special and warm welcome here to this meeting and symposium, Salvatore. You are currently working as Policy and Legal Officer at the AI Policy Development and Coordination Unit in the DG Connect of the European Commission in Brussels. You hold 2 master degrees related to European studies, related to law, and you are working now already for about 10 years in the European Commission. You have been for quite a while a 6 years experience in the medical device unit of DJ Grow, where you also dealt with the negotiations of the new regulations on medical devices and the medical device software dossier. And you are now very deep in, of course, the regulatory framework for artificial intelligence in the European Union. Salvatore, the screen is now yours, and we are very happy to follow now your presentation.
Thank you very much. First of all, I hope you can hear me well, and I'm very pleased to be there with you, and thanks for the invitation, but also for your kind introductory words. The idea would be today indeed to provide a kind of overview of this new proposed text that you have just mentioned. I will try to share my screen because I have some slides to present. It may be easier for you than to follow my presentation. I hope you can see my screen and
Perfect.
And the slideshow. Fantastic. Okay, so as it was indicated, the European Commission came up with a quite comprehensive initiative on artificial intelligence. I would like first to mention anyway that the regulatory framework is only part of this comprehensive initiative, because the initiative that was presented and adopted on the 21st of April of this year, so just some weeks ago. There are fundamentally 3 parallel initiatives. One is the proposal for the regulatory framework, and I will focus primarily on this. The second one is a coordinated plan on artificial intelligence, so basically a plan to present and identify key initiatives, also in terms of investment, to be taken by Commission and Member States over the following years. And the third important document, I will not talk about this later one, but it is still important to mention it, it's the revision of the machinery regulation, which will result in a new regulation on machinery. And of course, as you know, there are also many products, many medical devices that have also to follow in conjunction the requirements of the machinery regulation. So it's also certainly something of relevance to the medical device sector. But I will focus on the first two initiatives. Starting from the proposal for a legal framework on artificial intelligence. Before moving into the actual contents of the text, I would like just to briefly mention what is the general approach of the Commission when coming to artificial intelligence. Fundamentally, we believe that artificial intelligence produces very good and important benefits for the society at large, for citizens, for business, for public interest. At the same time, there are some risks which are associated with AI, and notably with what we consider high-risk AI systems, which concern safety and fundamental rights. And these risks must be tackled, not only for the safety and protection of fundamental rights of users and consumers, but also, conversely, also for facilitating the uptake of AI, because we feel that these risks that I've just mentioned may also hamper the proper uptake of AI within the EU, and thus limit the AI potential in many sectors. And in fact, President von der Leyen, she mentioned in her State of the Union speech of 2020 that this is a world of opportunities. The AI world is a world of opportunity, but this world needs some minimum rules. And now we come to the key regulatory concepts of this framework. I'm, let's say, in an easier position today because I talk to people who are very familiar with the medical device framework, and you will see how many similarities there are in terms of approach taken. Also because the medical device framework is quite an advanced framework in terms of regulatory logics. Also, the proposed regulation on artificial intelligence, which is a horizontal regulation, so covering together many sectors and many different products, relies anyway on the general principles of the EU acquis on product legislation. So basically it sets classical internal market rules for the placing on the market and putting into service of AI systems. In terms of scope, just to mention that I will present which specific cases and AI are under the scope of this regulation, but there is certainly one caveat, which is the AI systems having a military scope, military purposes. These are explicitly excluded from the scope. When we come to the approach and the consideration of risk, we try to take a very balanced and proportionate approach. We didn't want to regulate, over-regulate and stifle innovation in the field. So we wanted really to create and to lay down some rules for cases which we consider to be high risk. So we really stick to a risk-based approach. And the final general consideration, we try to create also level playing field for EU and non-EU operators. That is quite typical in EU product legislation. So we want the rules to apply in the same manner, regardless of the location of the operator. Now, the first important consideration is about the scope. What is artificial intelligence in this regulation? We know that this is a very divisive topic among the experts. We have tried to provide a definition which is as neutral and comprehensive as possible, and also to rely on a definition which has been adopted by like-minded partners, because in fact we built on the OECD definition of artificial intelligence that you can see here in this slide. The overall aim is to cover all AI, including traditional symbolic AI, machine learning, as well as hybrid systems. We know very well that already from stakeholders we have received some feedbacks and concerns regarding the, let's say, the large extent of this definition and the fact that it may cover also some traditional software. But just a general word on that. It is important to say, first of all, that the definition must be always complemented with the list of technique which we list in Annex 1. That is a fundamental consideration. So in fact, the definition say that we refer to software which is developed with one of the technique listed in Annex 1 to the regulation. And secondly, as you will see in the following slides, of course, the scope of this regulation is primarily on high risk. So it's not just about being an AI, being developed with one of these techniques, it's also about being a high risk in accordance with the criteria that we'll try to explain. The Annex 1, final consideration on this slide, can be updated in order to, let's say, take into account technical development. So the Commission has an empowerment to modify the list of technique and approaches on AI, which are under the scope. When I talked about the risk-based approach, I meant fundamentally what you can see in this slide. We identified 4 levels of risk in this regulation, starting from the unacceptable risk and moving down with high risk, transparency risk, and minimal or no risk. The upper level is what we consider to be subject to prohibition because it contravenes EU values. Then the high risk is the real core part of this regulation because most of the provisions are about high-risk AI systems. Then transparency risk are some AI systems which are not high risk but pose some specific transparency issues to society. And finally, the large majority of AI systems, also in the name of the risk-based approach and the targeted and balanced approach that I mentioned earlier on. So these are AI for which we don't want to set mandatory rules. So for the large majority of AI systems, things will continue to be as they are today. I will focus on each one of these layers, starting with the unacceptable risk. So we listed in our Article 5, some practices which contravene EU values and should be, in our view, prohibited. I will not go into too many details at this stage, but you can see the categories. So AI systems which can determine a subliminal manipulation or exploitation of vulnerabilities resulting in physical and physiological harm, the social scoring done by public authorities, and very discussed and controversial case, as you know from the press, the real-time remote biometric identification for law enforcement purposes in publicly accessible spaces. For this latter category, we set a ban, but with some exceptions, which are linked to certain uses of these AI systems by public authorities. Now, I start with the most relevant category in this regulation. The most relevant because, as I said, most of the provisions are about high-risk AI systems. And when we talk about high-risk AI systems, we talk within this regulation fundamentally about 2 categories of products. The first one is AI systems that are safety components of regulated products. For example, medical devices, machinery, notably NLF products that you may be very familiar. An AI system is a safety component of these products, and according to the sectorial legislation, medical device, machinery, radio equipment, toys, it depends. I mean, all these legislations are listed in Annex 2. When the product is subject to a third-party assessment under the relevant sectorial legislation, then the AI system would be also considered a high risk for the purpose of the AI regulation. For the medical devices, a specific consideration, which is actually quite peculiar, because we say AI as a safety component, but to be extremely precise, and in order to take into account the specificity of medical devices, we also say that AI as a safety component or as a product itself under the sectorial legislation, because in the medical device context, we know very well that there could be independent software, which is already a medical device by itself in accordance with the new regulation. So that means that also AI software, which is a software as a medical device, so a medical device by itself, if that software is subject to third-party assessment under the medical device legislation, then it would also be high risk for the purposes of the AI regulation. And I will tell you later on, of course, what are the consequences for all high-risk AI systems. The second important category is what we call standalone AI systems. So systems which are, just for your clear understanding, not related to products. And we have basically identified 8 areas which we consider high risk, but the actual high risk AI systems have been identified and listed by specific use cases. So the areas that you can see here are important, and I will explain you why. But in reality, from the outset, there will be some, not too many, a few high risk use cases within these areas that will be high risk from the outset and are listed in our Annex 3. Why, however, are these areas important? Because in the future, we can update the annex of standalone AI systems, but that can be done only within the pre-identified areas, also for the purposes of legal certainty. So this is important. This is why the areas are important, because we can introduce new use cases only within these areas. What is the consequence, regulatory consequences, when an AI system is a high risk? There are some requirements, essential requirements, just to use a very common expression in product legislation, which applies for the AI part. These requirements are related to high quality data, technical documentation and logging capabilities, transparency and information to users, human oversight, and robustness, accuracy, and cybersecurity. I want to highlight in this respect, like for medical devices and other new legislative framework legislation, our requirements are quite high level. So they basically set a technical objective to be achieved by the manufacturer. What are the instruments which operationalize these high-level requirements? Like in medical devices, it will be mostly through standards. So we want to rely on harmonized standards to allow for the operationalization of these high-level requirements. One horizontal consideration, which is very important in terms of requirement, is what you can find here on the left-hand side of the slide. So like in medical devices, so nothing different from that, we set an obligation for the AI provider to set, establish, and implement a risk management system, which should take also into account the combined application of all the different requirements. And the intended purpose of the system, exactly like in medical devices, is a key reference also for assessing and qualifying the compliance with the different requirements. So all the requirements shall be complied with, taking into account the intended purpose of the AI system. With regard to the obligations of the operators, like in other product legislation, we set the obligations for all the operators of the value chain. But certainly there are two operators which are more prominent than others and more important, and the ones that and they are the ones that are highlighted in this slide. Starting with the provider. The provider is a bit the equivalent of the manufacturer in our regulation. So it's basically the person, the operator, that places the AI system on the market or puts it into service. There are some obligations: the quality management system in its organization, the technical documentation requirement, the conformity assessment, the registration of AI system in an EU database, affixing a CE marking when the conformity assessment, of course, provides a positive result, a post-market monitoring, which is similar to what we have today as post-market surveillance in the medical device field, and the collaboration with market surveillance authorities. From the user side, we have also a few obligations. The consideration of the user is quite new in product legislation. Usually, users' considerations are not too detailed, but of course, for the AI system, the users hold a very important role. That is why we decided to lay down some minimum obligations, which are basically the following: operate the AI system in accordance with the instructions of use, human oversight obligations, always in accordance with the instructions of use, monitoring of the operations for detecting possible risks, and information obligation about incidents or malfunctioning. I want to reassure the whole medical device field, notably with regard to the provider's obligations, that we avoided any kind of duplication. So where the obligations are already set in sectorial legislation, there is nothing, let's say, to add, and I will clarify that just in a future slide. So basically, I take the example of registration, but also of conformity assessment. Registration of AI system will certainly not be required in the AI framework for medical devices, because there is already UDAMED in the context of the medical device framework, so we don't need a duplication in that respect. And also for the conformity assessment, as I will say, and will complement very soon, the requirements of the AI regulation for the AI part will basically be checked as part of the existing conformity assessment under the medical device regulation. Here, I won't spend really time on this slide. This is more for people who are not familiar with product legislation. So, because our system, like all product legislations, relies on the CE marking system. So basically, there is a compliance with the essential requirements to be ensured by the provider or manufacturer in question, a conformity assessment procedure. If the conformity assessment procedure provides a positive result, then the person shall affix a CE mark on the product and can place that product or put it into service, can place that product on the market or put it into service. Here you can have a broad overview of our enforcement system. And here also come some considerations that I made previously about the need for non-duplication, because we have a pre-market conformity assessment part, as you can see. So we have AI that are related to products that are covered by sectorial legislation. In that case, the requirements of the AI regulation will be checked as part of the conformity assessment, but there will not be a second conformity assessment procedure. For the other high-risk AI systems, what we have called standalone, the ones listed in Annex 3, we will have primarily an ex-ante conformity assessment through internal checks. So this is a kind of phased-in approach, not to create a major burden to operators that are today fundamentally unregulated, and with the exception of biometric. Biometric identification will be subject to a third-party assessment with notified body. Then you can see that the registration obligation applies, but only for standalone AI systems, not for AI systems related to, let's say, that are covered by existing sectorial legislation. And in the post-market phase, you can see we have the traditional market surveillance function by the authorities. We have post-market monitoring for providers, but also for users. And the same goes for reporting systems for serious incidents by providers and users. This will not also apply in the context of medical devices, just to be very clear, because there is already a reporting system for serious incidents in medical devices. So the reporting system for incidents will not apply to sectors like medical devices that have already a reporting system in place. And there is a general human oversight and monitoring by the users. This is something I already mentioned in one of the previous slides. I wanted, before moving to the last two layers, so the transparency risk and low or minimum or no risk. Just to complete this overview about unacceptable risks and high-risk AI systems, there is a case which is a bit in between, which is this biometric identification. I already said that there will be a prohibition for law enforcement purposes in publicly accessible spaces with some exceptions. For example, the search for victims of crime, the threat to life or physical integrity of terrorism, and serious crime in relation to the EU arrest warrant framework. Also, under these exceptions, anyway, there will be a need for an ex-ante authorization by judicial authority or independent administrative body. All other biometric systems, both of a real-time or ex-post processing nature, will be high risk, and they will be subject to an ex-ante third-party conformity assessment. And there are also some dedicated essential requirements, notably with regard to logging and human oversight. I promised that I would spend a few words regarding the two last layers, the two bottom layers of our pyramid here. There is also stuff which could be interesting also for the medical sector. In fact, when we look at these AI systems with transparency risks, the yellow layer, here, we didn't want to put too many obligations. We just wanted to target a need for transparency. So it is important that when we talk about chatbots, for example, or emotional recognition system, or biometric categorization systems, or very common case also nowadays, deep fakes, so where there are manipulation of videos, images done by AI, it is important that the person exposed to the use of those systems is informed that it has been interacting with an AI system. So basically, there is a fundamental information obligation. So we want to make sure that the person exposed to those systems is aware that there is an AI system working in that context. The yellow layer is the large majority of AI systems, whatever has not been mentioned in the previous layers, and there will be no mandatory rules. The only thing we decided to lay down is that Commission and Board could encourage the drawing up of codes of conduct, but also those codes of conduct would be of a voluntary nature. Just to conclude now on the regulatory framework, I want just to mention that there are some measures to support innovation. For example, measures to create regulatory sandboxes by member states, so protected testing environments where the compliance of AI systems could be tested. And there are also measures for the support of SMEs and startups. For example, specific considerations for conformity assessment fees, certain specific considerations with regard to the implementation of certain obligations. There will be a priority access to sandboxes, and also I mentioned that already, but I think this is also important when talking about SMEs. The system will rely on harmonized technical standards to demonstrate the presumption of conformity. So this is important, and we think that good standardization also is to the benefit of SMEs in particular. And now, a final slide. I want you just to get a grasp of how the governance system will work. Fundamentally, there are no major differences from EU product legislation. We have two layers. The day-by-day implementation of the rules is done by the national competent authorities. So the national competent authorities are responsible, of course, for the general application of the rules within the member state, for market surveillance, for checking the notified bodies. There will have to be also one specific authority, what we call national supervisory authority, being designated for the overall coordination of the activities linked to this regulation within that member state. At European level, we will have an artificial intelligence board. So the idea is to create a board with the national supervisory authorities, the European Data Protection Supervisor, and the European Commission, which could help and facilitate the harmonized implementation of the rules. I would say it's not so different from the medical device coordination group under the medical device framework. The idea is to have a European group that ensures a harmonized implementation of the rules across the EU. And now, just 2 slides before concluding on the second important initiative, besides the regulatory framework. It is this coordinated plan on AI. It is actually a review, because as you can see in this slide, there was already a coordinated plan in 2018, which listed many forward-looking actions. There were actually 70 already actions set in 2018, which developed together with member states. The general principle, so this joint coordination between Commission and member states, remained the same. But of course, there was a need to update this coordinated plan, notably because the world has deeply changed since 2018. There were really some fundamental and historical changes. Just let me mention the COVID-19 pandemic, the Green Deal, the Recovery and Resilience Facility that was adopted by the Commission, and all important technological developments since then. In the light of that, we decided to conduct a review. Also because we are aware of 2 fundamental things. First of all, there is a need to catch up with investments on AI compared to other jurisdictions. And in fact, the objective of the Commission is also through this plan to set a frame for a common joint investment, public and private, of 20 billion a year in the decade for artificial intelligence only. Second, it is extremely important to take advantage of the over 130 billion which are to be spent on digital in the different recovery and resilience plans by member states over the next few years. So, which is a huge leverage also for, you know, the uptake and development of artificial intelligence within the European Union. Here, it is just one slide. I cannot go for the sake of time through all the different actions, but it is certainly a document I would recommend you to read, because there are also some dedicated initiatives in the context of healthcare. There is one dedicated chapter, and it couldn't be otherwise, because artificial intelligence, one of the most important sectors where artificial intelligence will already, but especially in the future, can make a difference, is healthcare. So there is a dedicated chapter on that. But in general terms, you can see what are the 4 objectives set in this coordinated plan. We want to set, first of all, the enabling conditions for AI development and uptake in the European Union. We want to, let's say, create conditions for investments and for EU excellence throughout the whole value chain, from the lab to the market. In this context, let me mention in particular, for example, the creation of EU testing and experimentation facilities, including in the health domain, where basically in particular SMEs could test their products, including test compliance with the future EU regulation. The third important objective is to create the right, let's say, relationship between people and AI technologies. And this would entail in particular, and everyone recognizes this need, is basically to create talent and skills on AI across the EU that could really cope with this important revolution, which is already happening, but it is bound to increase more and more in the future. And the final objective is to build strategic leadership in the sectors. You can see healthcare, as I already mentioned, is one of the strategic sectors, together with others: climate and environment, robotics, public sector, law enforcement, mobility, and agriculture. This is not intended to be a closed list, in the sense that in the future we will have to periodically review this plan. Other sectors could be added. This is what we have, you know, for the moment identified as key sectors for investment and specific initiatives, but new sectors could be added to the list over the future reviews. This concludes my presentation. It's never easy, of course, to condense all this into a relatively short timeline, but I hope I could provide you with a good and comprehensible overview of these 2 very important initiatives, and I'm happy to reply to questions. Thank you very much.
Thank you so much, Mr. Scalzo, for this excellent overview on the AI proposal. It's really a fascinating topic, of course, and also the regulatory framework was really presented by you in a perfect way. I would like to invite all our participants to really take actively part in the discussion. Mr. Scalzo unfortunately cannot participate at the panel discussion today at the later morning, so that's why we would like to take advantage of his few minutes he still can give us. And we can use the chat. You can also raise your hands. You can use, of course, the microphone. By raising the hands, we will be able to see very quickly who would like to comment or ask any question to Mr. Scalzo. So there is already a first feedback from the chat from our participants. Mr. Scalzo, here's the question: could you please give a definition of a safety component? That is a question from Mrs. or Mr. Osikowski-Schröder. So this...
I reply straight away. Thank you.
Sorry?
Should I reply straight away, or should I take some
as you wish. As you wish. If you would like to answer to this aspect with regard to the safety components, it will be great. But we can also move on with other questions. There is Mr. Borzivoda who has would have a question. So
okay,
as you wish.
I can start with this one. I can start with this one because I think
Good.
It's also important.
Thank you. Thank you.
No, the safety component. Basically, we have a definition which is in our Article 3. We try to stay, because the difficulty the challenge actually with this horizontal regulation, like in all horizontal regulation, is to find an appropriate definition, not only for safety components, but for many aspects, which can be applicable to many different legislations and sectors. So we have tried to have a rather comprehensive and large definition of safety components by saying that fundamentally it is a component which has a safety function, and the malfunction of which may endanger the health and safety of persons. That is a bit, let's say, the definition, which is quite comprehensive. It builds on some precedents. For example, we have a definition of safety component under the machinery regulation. You may be well aware of that. Ours is a bit more large because in the machinery regulation, the safety component is also something that is sold separately on the market. For us, this was less relevant because at the end of the day, we want to cover both. So we decided to use the same concepts, but of course, to enlarge and to take off some limitations that were contained, for example, in that definition. So we try to be, let's say, as neutral and comprehensive as possible, I would say.
Mm-hmm. Thank you so much, Mr. Scalzo. Dominic Bozzivoda would like to raise a question or comment. Please kindly use your microphone and go ahead, please.
Yes, thank you very much for the opportunity. My name is Dominic Bozzivoda. I'm the founder and CEO of a German healthcare digital therapeutics startup. We use artificial intelligence. We are a portfolio company of Boehringer Ingelheim Venture Capital Fund, one of the largest German pharmaceutical companies, among others. And we've been out there for 4 years. I'm also a panelist later on. Thank you very much for the comprehensive and to the point presentation. It gave a really great overview on the intended regulation. I am concerned that we are limiting our economic potential at a time where we are already standing with the back to a wall in Europe. What I mean is, your examples for regulation were that people could use AI to manipulate things and to essentially engage in illegal behavior. You had an example where a doll was telling kids to harm themselves. I think that would be illegal today. The technology by which the doll is able to do that doesn't make the difference. You know, you don't need AI to do that. You can just produce a kind of doll that can do that, right? So you are trying to prevent something by limiting a technology and not an outcome. And I don't think that this is this will be an effective approach. This will not work. Second, I kind of have to thank the EU because, as I said, we are venture capital funded, and I don't see any competitors arising within the next couple of years because basically the regulatory framework for startups, it's impossible to fulfill. Right? If you're a newly founded company, you will not be able to finance auditors, to finance lawyers, to finance consultants. For the MDR regulation, which we are already working on, obviously, we are considering around 250 to 500,000 euros just to adhere to MDR regulations, and it will cost us only 3 full-time employees to get to the MDR certification. When you are a new startup that is being founded, that is impossible to achieve. You cannot achieve regulatory compliance under the MDR as a newly founded startup in the current EU venture capital markets and funding markets. And it doesn't matter how many EIC accelerators or whatever funding programs, Horizon 2020 programs you will issue, it will not solve the problem because not every the approval processes are way too long. It's way too slow. These programs are not catered to the need of a dynamic startup environment. And I'm really concerned that this regulation will bring us in a really bad position throughout the next 30 years.
Thank you,
Yeah.
Mr. Bozzivoda. I think this is you really address a very important and relevant point. Thank you so much for this comment, more or less, Mr. Scalzo. Maybe your feedback to this strong comment, which we will probably also pick up again during our panel discussion. But what do you say? So, is there really a need for such a complex and somehow lengthy regulation on AI, which could have maybe, let's say, effects that we wouldn't wish for the European Union and for those that are, I mean, you know, especially startups, companies, SMEs who are working in this field? What is your impression about that? What do you say about that comment, maybe?
No. First of all, thanks a lot also for the clarity and the frankness. And I mean, it is important also to discuss also and to also on the basics of why something is needed, rather not only about the contents, I would say. And I also invite all of you, because you know that we have this is a traditional process in the Commission. We have also a feedback process after a proposal, which will land on the 6th of August. So I invite really all the people who are interested also to contribute, because we really need to see what are the reactions of the most important stakeholders, certainly with regard to this regulation. I mean, of course, there was a lot of reflection behind this regulation. There was a reflection, first of all, on whether it was needed and how to make sure that the level of disruption would be proportionate. I call it disruption, but let's say the level of burden, notably for sectors which are already regulated. With regard to why it is needed, also studies prove, we believe that notably when you come to the use of a new and disruptive technology, the notion of trust is extremely important. It's extremely important for the uptake of that technology to a large scale. So for us, building the conditions for trust is really fundamental. The second important point, we also see this as an opportunity for the EU market, because of course it will come with a short-term investment, there is no doubt, for the ones who are, of course, developing high-risk AI systems, notably. But we need to take into account two things. First, at the international level, things are moving. So we have the opportunity there to set a standard which could be, let's say, ours, and perhaps influence the work of many like-minded partners who may come up with similar initiatives. So this is certainly an opportunity also at the international level. Internally, we also saw a lot of activities from member states. So the worst we could see is that there could be some national initiatives, more or less burdensome, that would pop up within the EU. And that would create a fragmentation of the internal market as we see it today. So there was also, because of that consideration, I need to come up with some rules. With regard to the so these are for me very important considerations, because we saw already that there were many member states having a strong interest to come up with something. So at that point, we say it is now important that on such a new innovative field, there can be something at the EU level to set a common European standard and avoid that there is fragmentation across member states. With regard to the contents, really, in particular for the medical sector, we try to be as, I use this expression, as surgical as possible. At the end of the day, I honestly believe, and this is also based on our analysis, that for serious operators, the additional burden linked to this regulation will be very limited, because we know already that today there are some requirements on software in medical devices. So it's really not something new. What we would add is basically fundamentally for the medical device sector, it's primarily about the requirements. So there would be some additional essential requirements that would be added on top of the sectorial ones and for which the provider shall claim conformity. I would say that compared to the current situation where you have just general requirements on software in Annex 1 to the medical device regulation, you may rely, thanks to the AI regulation, on harmonized essential requirements for the AI within the whole of the EU, rather than, seeing maybe divergent practices with regard of how AI shall comply with the very general software requirements of the AI framework. So I honestly believe that the added component of the AI regulation for medical devices will be relatively limited. Of course, there were also considerations about compliance costs with the MDR that I'm certainly aware that it is a big challenge. Of course, I cannot really say too much about that. For obvious reasons, I have to focus on what I believe is the effect of the AI regulation. There is one final point that you mentioned, which is about these deep fakes. I totally agree. I totally agree that, you can never prevent fraud. I remember there was the old discussion about the PIP scandal in the medical devices, when you can say at the end of the day, whatever law you can put into place, I mean, if there is a fraud and there is a bad intention, no law probably can solve that. I mean, can minimize the risk, yes, but of course, I mean, it cannot really prevent the possibility that people go into fraudulent activities. However, just with regard to that, I would not say we blame the technology as such. Not with regard to the example you made, we just set a notification obligation. So it's a really minimal information obligation, which which is intended really to protect and safeguard the people who are exposed to this technology, taking into account that also with regard to ordinary stuff like deepfakes and manipulation of images and videos, the ones you mentioned, the AI has the particular characteristic in our view, and this is something you can find also in our impact assessment, it brings the potential of misleading practices much higher because of the nature of the technology. So it's not about blaming technology. I would say it's just seeing what is, try to take also a realistic approach. And anyway, the consequences in terms of regulatory effects, we try to keep it to the very minimal because it's just a notification obligation. I don't think there is any blaming effect on the technology or any way to constrain it. That is certainly not our intention. That's why I said in the end, we just target a minimal transparency risk that we see in it. Then it's possibly also, I agree, it's a clarification of what is already there, so nothing more. Probably already today, serious operators would inform the counterpart. But, we provide some legal certainty, and it is only about a notification aspect. Thank you.
Thank you so much, Mr. Scalzo. Thank you so much for these explanations. Some few more minutes are maybe left, maximum 5 minutes also from your time. What is very important, the timeline again. You mentioned the consultation period. Could you maybe just give us again an overview on, let's say, the further processing and development of the AI proposal? What can we expect about the timeline of application?
No, definitely. So this is clearly a proposal from the Commission. So it's not law, it's just a proposal which has now accessed the negotiation with the European Parliament and the Council. So we are at the very beginning of the journey. The Commission, so the first step, which is relevant for stakeholders, we intend to carry out this public consultation. The Commission always does after the adoption of a proposal. So there will be a public consultation until the 6th of August, as already indicated. So stakeholders can comment the text of the regulation and make also proposals for improvement. This is until the 6th of August. From the co-legislator perspective, we cannot predict, of course, for obvious reasons, what is the timing of the negotiations. We have estimated provisionally, but take that with all the necessary caveats, because that will depend very much on Parliament and Council. We say 1.5 years, probably something like that. And you should add on top the transitional period. The Commission in the proposed text has foreseen 2-year transitional period. So if you add the 1.5 years of negotiation to the 2 years transitional period proposed to the Commission, that will make 3.5 years from now. more or less. So we can reasonably foresee this regulation to enter into effect, into application around the Q1 2025, more or less. Then this is, once again, with all the caveats, because first of all, we don't know when it will be adopted. The second, the transitional period set by the Commission of 2 years could be modified by the co-legislators. But at least I can provide you with a kind of more very preliminary and general estimation.
Thank you so much. That's very helpful. Maybe one more thing about the sandboxes. There's a question from Robin Seidel about the elaboration on how the sandboxes will work, especially how the Commission sees the national authorities in this. That's maybe a question of many of our participants. What about those sandboxes? What does it really mean, and what kind of, how they are, how should they work?
But in short, because I'm also happy to provide you with more explanations, we have tried to also later on, and also because this is also an aspect, which has deserved a lot of attention, also with regard to implications in terms of legal basis for processing personal data. So I will not go maybe into that level of detail, but fundamentally we wanted to create an instrument, or to facilitate an instrument, because at the end of the day, it will be up to member states to create these regulatory environments, protected regulatory environments, where operators could be in a position basically also to test their products, to check their compliance. It is also true that sandboxes may also serve the purpose of, let's say, other linked purposes. For example, we have considered also in general terms the possibility to test the environmental implications of AI. Maybe it's not an immediate and regulatory aspect. So just to tell you that this regulatory sandbox could serve also other purposes. But fundamentally, the reason for creating it is that we want to create at the member state level and encourage member states to set an environment where people could test under protected conditions their AI systems, get the support of regulatory authorities, and be sure that the kind of design and development practice that they develop are in compliance with the rules of the future frameworks. This is something, of course, once again, the member states should establish in accordance with the minimum rules of the regulation. What we also said is that some relevant authorities shall be associated to the exercises. For example, let me mention on data, it could be also the data permit authorities that were relevant shall be associated, or any specific authorities that may have a stake in the processing of the data, in the testing of the AI system in question. So these are the fundamental, I would say, aspects that we have set in the framework. It will be very much up to the member states to set these schemes, and to the Commission, with the help of the board in the future, to try to harmonize certain aspects and certain practices in this context. This is what I can say, just in a nutshell.
Yeah, thank you so much. One last comment from your side. Where do you personally see any need for improvement or any gap in the current draft AI proposal related to medical devices? What would you say where could still be an improvement? Or where do you maybe see challenges with regard to the medical devices sector?
But I must say that as you mentioned, the medical device sector, I have difficulties to say exactly where. So I prefer to make rather, let's say, more general statements, yes, also with regard to the background, in the sense that it was for me extremely useful to have quite a long experience in the medical device sector, because that allowed me also to, when contributing to this effort from the unit, to ensure an appropriate level of linkage between the two acts and minimize the burden. So the text results from a very deep reflection, aiming really at minimizing the level of additional component brought forward by this AI regulation to the already comprehensively regulated medical device sector, and also to ensure that, let me say, that we could avoid any kind of additional duplication. So the idea was to avoid the duplication, and that is with regard to the conformity assessment, that is with regard to the registration, that is with regard to certain obligations of manufacturers. Now, if you tell me, I think therefore that in that you can be reassured that there was, and hopefully you can also recognize when reading it in detail, that there was a really an accurate reflection, which was also conducted, of course, in coordination with the colleagues in charge of medical devices. Of course, probably we could be interested, I mean, you can never say the text is perfect. Actually, we recognize that there are areas that could be possibly and should be possibly fine-tuned. Of course, there is an expectation, in particular from the operators in the sectors, that you could identify perhaps areas where, you know, a better linkage could be ensured, or, you know, where, for example, there are clarifications that may be provided, because we tried already to provide many in the context of many articles. But if you feel, for example, that there are areas that remain a bit uncertain with regard to the joint application of the two texts, I think from our side, we will be extremely interested to receive this feedback, because the text has to be improved and has to be made as perfect and clean as possible. So from that perspective, we would really value the possibility to receive feedback. I cannot identify, I must say, an area which may deserve more development than the others. I would rather indeed probably ask the operators in the medical device sector, because I think the stakeholders are always the ones in the end who have the most sophisticated knowledge of how things work in practice, to point to any element that may deserve additional clarification. I think in that context, we would definitely welcome your views and your suggestions.
Thank you so much. This is a very motivating point again, and a very motivating aspect. So thank you so much, Mr. Scalzo. So I think we should move on. There is only a few number of questions or comments left. Maybe we can later on address them again in a personal communication if possible.
Absolutely.
Or right, that would be great. Or also you mentioned the consultation period, so further open questions might even be then raised and also clarified later on. We are very happy that you gave us such a really excellent explanation and overview on the AI proposal, and we really appreciate your open mind and the discussion. Thank you again so much. We wish you a beautiful day ahead. Of course, you said that you unfortunately have to leave because you have a lot of other meetings to participate. And
that's a dense period, as you can imagine.
Yes,
with the start of the negotiation.
Of course. Again, thank you so much. We keep in touch, and we are sure that we will be able to discuss some more aspects.